We're joined now by legal analyst Barry Covert to talk about that hot topic issue, of course, bail reform. Barry, thanks so much for speaking with us tonight.
Absolutely.
So we just heard that soundbite from acting Mayor Chris Scanlon. Very strong words talking about bail reform. Of course, under the bail reform laws passed back in 2019, could you go through what exactly determines whether someone receives bail, whether they're released on their own recognizance in the case here that we heard about, and of course, whether they are held without bail at all?
Generally speaking, for violent felonies, the judge is permitted to set bail, and then the judge is supposed to look at many factors in determining what level of bail to set. Now, for the offenses committed here, the first night where he committed the burglary with the armed firearm, those are violent felony offenses. The judge did set a bail of $50,000. The purpose under the Bail Reform Act, though, is to assure that the defendant is going to appear in court. The changes in the law in 2020, and even though that law has been amended 3 times since 2020, still has not included looking at the individual's dangerousness in determining whether a bail should be set, what amount, or whether it should be set at all. And so in this case, after the day of the burglary and possession of a firearm and choking the poor victim, the judge set $50,000 bail. And again, the purpose of that is to make sure he shows up in court again. The next day, he's alleged to have violated the court order, the order of protection. The judge in that case could have also set another bail or remanded him in that instance because of his failure to abide by the order of protection. So there are a lot of factors, including an individual's history, the strength of the case, that go towards whether a bail should be set. But the underlying purpose of bail since 2020 is supposed to be to make sure that the person comes back to court, not judging their dangerousness. And in some instances, we've seen these types of examples of somebody who, in this case, is convicted of a prior murder and then engages in allegedly violent behavior, getting out on bail or low bail or no bail, and then committing subsequent offenses such as in this tragic murder. And it does seem to be a little unbalanced.
You bring up dangerousness and, of course, the suspect's history. So I want to just give detail, and of course, you weren't seeing it, but the viewers at home were seeing some video back from 1997. Ricky Crouch, he was previously convicted in the late 90s in another homicide case. At that time, according to police reports, he was involved in the death of a teenager who was an innocent bystander during a gang-related shooting. However, police say he was released early a couple of years ago. He was no longer on parole during this incident. With that said, would all of this history affect a judge's decision when setting something like bail?
The judge is supposed to be looking at what bail is necessary to have the individual show up in court again. Looking at the individual's history is one of the factors that the judge can look at, but it's not supposed to be determinative. It's only supposed to be determinative as to the determining factors are supposed to be whether that individual will show up in court for the next court appearance. Again, dangerousness is not included as one of the factors that a judge is to look at. So it puts the judge in a very difficult position. You have the district attorney saying, this guy's dangerous, please don't set a bail, leave him in. But the legislature set standards now in 2020 and didn't change it in the 3 amendments since 2020, stating that no, you're really only supposed to look at what is required to get him to show up in court again, not the underlying dangerousness of the individual. And it's a tough position for a judge in any event, because even if the judge were to look at dangerousness, are we going to say that somebody who committed a prior murder, served his time, paid his debt to society, and is alleged but has not been convicted of a subsequent offense can never be released on bail because you don't know that they're not going to go out and murder someone? It is a tough balancing act. But in this case, we do have a victim of the prior burglary, of the prior choking. He was caught with a loaded weapon, and it's certainly understandable for people from the outside of the system to wonder how could he have been released on any level of bail given that he had committed a prior murder.
Sure. So there were those incidents that happened that we heard about in May, all involving Thompson, the victim in this case. So this really does seem like a case where the victim did everything correctly. She went to the police, she reported these incidents, yet this was still the outcome. So what do you think this says to victims of domestic situations, and how can they make sure that they get the justice that they deserve?
It's hard to imagine what else she should have done, and that's really going to be on the legislature to look at this and decide what tweaks we need to enact in order to make sure that something like this doesn't happen again. Because she went to the police, she had him charged with the first robbery, choking, possession of a weapon. Then within 24 hours, is my understanding after looking at the paperwork, he goes back and he violates the order of protection. He was previously convicted of a murder. There should be more discretion given to judges to set bail or no bail in instances where the individual clearly has shown that he or she is a dangerous person, especially when they're targeting someone. But to answer your question, I don't know what else she could have done in this case to protect herself other than to move out of Buffalo so that he wouldn't find her. And that's not reasonable to expect of anyone, and it just re-victimizes the victim over and over again.
All right, Barry, that's all the time we have tonight. Thank you so much for joining us and taking us through all of this.
Thank you.